case information?
Oh, I didn't even check it. Sorry. Should I and how do I take it off? Because what happened is they're gonna get live to start, but the parties I can't talk with this. The parties are gonna make an application to not have it live.
Okay, so what you're
And
gonna do,
then
you're gonna kill this right now because you've got it under the wrong name, and it's gonna be under the wrong name when it gets posted. So since we haven't really started anything, we can kill it.
anyway, so let's cut it now. How do we do that? How is it the wrong name?
Is that the right name for it?
Yes.
Oh, that's the right name?
Yeah.
Okay, that's what I said. Is that the right name? And
Yes.
you didn't change it. Okay.
No, I said I didn't check it.
Okay.
Yes, they're gonna
So,
get live to start. But the parties I can't talk with this. The parties are gonna make an application. Not have it live.
Okay, so what you're
And then so then I have to I can copy this just in case.
We're
Copy and
recording
paste
right
it.
now?
Yeah.
And it's gonna be under the wrong name.
I haven't started that yet.
Okay. In that case, let's stop. Go to your Zoom
How's it the wrong
session.
name?
Is that the
I
right
can
name?
pause it, right?
Okay. Actually, no. Hit play. Go ahead, hit play.
Yes.
Oh, that's right name?
Yeah.
Now, over here, I want you to turn off your
No, I didn't check
microphone.
it.
I want you to mute this. Okay, good. Because otherwise that's going to interfere with your phone smart.
Okay,
Now, let's move this down.
but I have to copy and paste it just in case, right? So Vita can send it out.
Correct, yeah,
okay.
right. So go ahead and send that out. But I would go and turn
I didn't
off,
copy it.
I would pause the Zoom right now or mute yourself until you're ready to go forward. unmute. Good.
But the judge is going to be waiting for me one second. Just a second.
Okay, so we don't have anybody. Okay, so what I'm going to do here is I'm going
Okay, that's the-
to over here. I'm going to leave this here because otherwise we're going to get feedback.
Hi, Justice Ibarra.
Yes, Gina, thank you. Good morning, Frank.
Right?
Are we at the start?
Yes, we're just going to let the other parties in if that's okay for you.
Sure. Okay, thank you.
Okay. So this is right. This is good.
I know, that's fine.
Okay, so I'll let you think how you're good.
Thank you.
Any problems, give me a call, okay? I'm going to be in another course.
How would I kill live stream? Sorry.
Excuse me?
How would I kill it if I need to?
Live stream kills how would you kill live stream?
Yeah.
Go to
Go back to more and then stop it.
no, go to more, yeah. Click,
I don't want to kill it
no.
now. Sorry.
Okay, right here, click more there.
Mm-hmm.
Okay, you gotta click up here to get rid of that there. Now click more. Okay.
All right, then I stop it. Okay, thank
Okay.
you. All right.
Yes, good morning, Mr. Jerome.
Good morning, my lady.
And I'm just waiting for Ms. Tucker.
Good morning, my lady.
Yes.
Mr. Durham is wigged and robed. I'm not certain if I should be as well.
It has not been the practice for counsel to wear their gowns and their wigs for remote hearings. Although I have to applaud Mr. Durham for erring on the side of caution.
Thank you, my lady.
And it's better to be overdressed than underdressed in
Indeed.
these kinds of circumstances. All right, this hearing is starting out as an open court proceeding, so I'm going to have Ms. Oswood read the court heading, and then any preliminary applications can follow.
Right.
Friday, the 4th day of June, 2021, court via Zoom at 11:04 a.m. before Honorable Justice Sybil Williams, Appellate Jurisdiction 2020, number 3. Keiva Maronie-Durham versus the Bermuda Bar Council. Mr. J. Durham for the appellant, Ms. Sarah Tucker for the respondent.
Yes.
Thank you, my lady. My lady, I, of course, appear on behalf of the appellant. My learned friend, Ms. Tucker, appears on behalf of the respondent. My lady, I trust that you have seen a correspondence dated the 3rd of June, 2021 from my learned friend, Ms. Tucker.
With the supplemental submissions. And
Mhm.
also, I think that there was some correspondence expressing concern about the court proceeding on an open.
Yes, my lady. It's the latter which I seek to address your ladyship on. We do join in the concerns raised by my learned friend in regards to the proceedings being open and there being matters of sensitivity as a result of matters having not been determined as yet. So it would be my application at this point in time that the proceedings be made in chambers. Of course, I'm in the court's hands, but like I said, we do join in the concerns raised by my learned friend in that regard.
It's not an application that can be made passively. If you're going to make an application before me for a confidentiality order or anything to that effect, the application will have to be made fully. This is an appeal that would ordinarily, we're proceeding under section 10G of the Bermuda Bar Act, where the court is sitting in its appellate jurisdiction. The starting point is always that the proceedings will be in open court. And I have to say, it's most unlikely that I will be moved to depart from that ordinary practice on the basis that there are matters of sensitivity, as you put it. You'll really have to, I think, address me more fully. Now, I don't know if you're prepared to do that now or not, but this would be the appropriate time, because otherwise I would want to then continue.
Sure, my lady, in the interest of time, we're happy to proceed and take your lady's point. And in that regard, my lady, moving on, just as a matter of housekeeping, I trust that for her, the relevant documents that have been filed, namely the.
Sorry, Mr. Durham, Mr. Durham, before you move on, let me just make sure that Ms. Tucker, because I understood the point to be initially it was raised by Ms. Tucker, so Ms. Tucker may want to.
Okay.
That.
Yes, my lady. There was an issue of whether this matter forms sort of a hybrid in terms of the position of the court. It's one that the court has not been seized of in the past in terms of hearing an application from the regulatory authority of the council and what the facts are in terms of persons who have made complaints. Confidentiality is obviously of some importance, and unfortunately, I myself have not made an application for this matter to be heard in camera, not so much in chambers, but most certainly in camera. And at this time, I don't have any documents before the court with respect to that myself. I am prepared to have this matter continue based on expedience of time and due to the importance of the subject matter. But there was just a concern raised regarding the facts that will come out. I would hate for us to breach any sort of privilege of these persons who are touched by these proceedings.
I mean, I would not expect for any breaches of legal professional privilege to be made before me, whether, quite frankly, we are sitting in camera or openly, unless there has been a proper waiver of that privilege.
And this, if I can just mention, this was an issue I had recently stumbled upon as I inquired whether or not the matter was going to be heard in court, as I was advised that the sitting would be over link, which was fine, but you
were advised, sorry?
I was advised that the hearing would be over remote link, remote access.
Yes.
But I was also advised that it was going to be live aired over the Supreme Court channel. So my concern was the live airing of it, not so much the recording of it. And I would not take it lightly that I, as the professional body in terms of the Bermuda Bar Council, does not have the consent to discuss the complaints in our possession at this time for the live hearing of this matter.
I'm not sure I follow you to be plain about it, Ms. Tucker. For the purpose of these proceedings, I would not know whether or not it was necessary for you or for Mr. Durham to have obtained any kind of waiver in relation to legal professional privilege. If you have obtained a waiver, then it would be for you to then inform the court what the confines or the boundaries of that waiver might be. So for example, it may be that for the purpose of these proceedings, if they were to be heard in camera or you're asking for it to be anonymized, I really want to be, I think, addressed in better detail. And it's not clear to me yet. I'm a little sympathetic if you had some belated appreciation for the fact that the hearing was going to be held openly, but that would obviously be the normal course for any appeal. So if we weren't, for example, if we weren't hearing this remotely, but let's say that we were sitting in the Supreme Court and members of the press wanted to come into the courtroom and fully report in the proceedings, that would be, you would be no different of a position, at least as a matter of principle, than you are now with the matter already streaming. I mean, how wide the audience is not really the test. It's the test as to whether or not the public have access or if they don't.
Yes, and I definitely agree with that. And in regular course of action, oftentimes the media don't name names in terms of the subject, the names of the subjects that are being.
You have to make an application. If you want some sort of, and I'm not barring you from making the application. You're open, either of you are open to make any application, whether it be for anonymity, whether it be for confidentiality. I'm just giving you some insight to what my opening position is that that's not an application I want to hear passively. You can't, in my provisional view, the starting point is that these are open court proceedings and there has to be a good reason to depart from that. So you really should make the application properly.
Yes, we're certainly heard. And I would make the application for anonymity. However, I don't have those, I don't have any substantive arguments to be made at this time on why this matter should fall outside of the normal boundaries of Order 55 open court proceedings. I would just be asking for an anonymity on the part of counsel if the matters can be referred to by number as opposed to names that could assist in how we proceed in this morning's hearing. As the numbers are the bar council complaints and they then reflect the names, which would be
yeah, you're making that's how you would give effect to any order that I make for anonymity. You have to first convince me that I should make such an order.
Yes, my lady. Well, because this is a hybrid situation where we have matters that involve complainants that have brought complaints to the bar council, the bar council would not normally have a seizure, or those complaints would not normally be made public or aired publicly. Those records aren't given access to persons outside of the
I see. So it's the names of the complainants that you want to withhold from.
Yes. Yes, my lady.
Public arena. I see.
And because these matters touch professional breaches of contract and a relationship between the council and their clients, those matters, some of which have not gone past even adjudication before the courts.
Yes. I mean, okay, well, let me just cut through that. I think if you're talking about the complainants only, I don't have any issue with you referring to them by initials. I think to do it any other way might confuse me.
Yes.
But I would be prepared to allow you to anonymously refer to the complainants.
I'm satisfied with that, and I will refer to them by initials, my lady.
Okay. Anything further on this point or on a similar point?
No, my lady, not for myself.
No? Okay. All right. Let me just make a short note. Yes, thank you.
Thank you, my lady. Proceeding on. My lady, this is, of course, an appeal against a decision by the Bermuda Bar Council, which was dated the 9th of December, 2019. And the rationale for the decision is contained in a letter dated the 9th of December, 2019, which was addressed to the applicant and sets out the reasons for the decision to refuse a fit and proper certificate as such. Before I move on, my lady, I just want to be clear that your ladyship has in her possession the notice of appeal dated the 6th of January, 2020, and the subsequent amended notice of appeal filed by the applicant dated the 3rd of November, 2020.
I have the amended notice of appeal open before me. That is,
I'm grateful.
has a filing date for the 3rd of November,
Correct.
2020. Is that what
Correct.
we're concerned with?
Yes, my lady.
Okay.
In addition, my lady should have a record of appeal. Both the respondents' initial skeleton arguments and subsequent supplemental submissions. In addition, I believe the respondent has filed an affidavit of Ms. Christopher of today's date.
I've seen an affidavit from Ms. Christopher earlier on in these proceedings. Let's see.
Yeah, there was a most recent one, my lady. I believe the date of that filing is the 4th of June.
Okay, just one moment. The affidavit I was referring to was filed with the Supreme Court on the 30th of October, 2020, and it has the same swear, the affidavit was sworn on the same date.
Right.
My lady, it may not be that you are seized of that document as of yet. I emailed this affidavit. It's a recent affidavit in terms of most recent, which I emailed at 10:30 today. It simply attaches the update on the PCC matters on behalf of the president of the Bar Association. And it was sent to the Supreme Court email and to an admin assistant there. I tried to call, but I could not get anyone to forward it on. I didn't get confirmation that it was forwarded on to you as of yet.
That I can see some recent affidavit added, but it's clear to me that it's not in relation to this matter. So that is by administrative error. So that aside. Maybe Ms. Aswood, you can assist in this regard in helping me to put my hands on the most recent affidavit, please.
Ms. Aswood, if I can have your email, I can forward it to you right now as we speak.
So it's gm@gov.bm.
GM, say?
Yes, GM as in mom.
Oh, yes, I see you.
Thank you.
I'm grateful, thank you.
Thank you.
Yes, can we continue?
Yes, thank you, my lady. So my lady, in referring to the decision, and that decision is found at page 97 of the record of appeal. The substance of the decision is as follows. In making its determination, Bar Council considered your previous conduct and activities in business and/or financial matters. In particular, Bar Council had regard to the following: Section 10E4C4, in which you have demonstrated that you cannot be relied upon to discharge your financial duties as a barrister, as you have 3 pending PCC tribunal matters that are all in relation to financial complaints. And then they named the 3 in particular, which is PCC
No need to,
344.
you don't have to name them at all. It's in front of me, and that's what we're trying to do.
Yeah, I was just going to refer to initials, but I'm grateful.
Okay, all right, but I can see the names, yes.
I'm grateful. And then they continue, you have within the preceding 5 years been admonished in relation to your conduct. And then they refer to a matter dated the 23rd November 2015. And then they go on to outline the decision in which they state, we have considered the severity of all the relevant circumstances. However, in reviewing your previous conduct and activities in business and or financial matters, Bar Council must deny your application for a fit and proper person certificate, and therefore will decline to issue you a practicing certificate at this time. So that is the decision that we appeal against, and the rationale for that decision.
Right.
And so, my lady, as you will have seen by way of the amended notice of appeal, the grounds of appeal have been narrowed to 3 particular grounds of appeal. And firstly, that is that the Bar Council's decision was unfair, and that at the time of consideration, the Bar Council failed to provide the applicant any adequate opportunity to redress matters that might have led it to conclude that it was not satisfied about her being a fit and proper person to practice law. Secondly, the existence of the complaints of which the applicant is innocent of until proven guilty have been used to adjudicate her fitness to practice in violation of her right to natural justice. And lastly, my lady, that the determination of the Bar Council was unduly harsh in all circumstances. So taking them firstly by chronological order, my lady, I'll deal with the inadequate means of redress. And my lady, you'll note from the supplemental submissions of my learned friend that the parties are in agreement that the principles of natural justice are applicable, or were applicable, to the determination made by Bar Council. And further, that those principles encompass a right to be heard. So the applicant should have had the opportunity to speak to the concerns that were raised by her fit and proper certificate application form and subsequent matters of conduct. And so we say that having accepted that natural justice applies to the deliberations and that this includes the right to be heard, the respondent now seeks to rely on the doctrine of a de novo appeal, which is essentially an appeal by rehearing, which Order 55 prescribes that these proceedings are by nature an appeal by rehearing. And so they say that they can rely on this doctrine insofar as that they assert that the Bar Council's determination can be cured by such a rehearing to any extent that it did not accord with the requirements of natural justice to afford the applicant the right to be heard. So essentially, whatever flaws were prevalent in the deliberations can be addressed by this court at this time. And so we say, while it's accepted that such a cure is recognized in law, it does not assist the respondent in the circumstances of this case. And the reason that it doesn't is because, again, in reaching their decision, the council relied on matters which are properly the jurisdiction of the Bar Disciplinary Tribunal, namely the 3 PCC complaints which were referred to Bar Disciplinary Tribunal. And in this regard, this court cannot look into the merits of those complaints because they are before the Bar Disciplinary Tribunal, and because this court exercises an appellate jurisdiction, meaning there must first be a determination of a lower court or tribunal before this court's jurisdiction arises. This court cannot act as a substitute for the Bar Disciplinary Tribunal. And in the circumstances, a rehearing of the decision doesn't really get us any further. It simply takes us back to a situation where the complaints are in existence and have been referred on to Bar Disciplinary Tribunal, but there is no authority or there's no remit for any other tribunal or court to look into the merits of those but the Bar Disciplinary Tribunal. And so we say that for these reasons, Mrs. Durham was not in a position then, nor is she now, to speak to the merits of the allegations and have them properly considered, as only the Bar Disciplinary Tribunal has the statutory authority to do so. So, my lady, the right to be heard, we submit, must require that the evidence given is weighed and considered in the reaching of certain findings of fact. And the only place for that is the Bar Disciplinary Tribunal, which is the statutory body formed for such procedures. Mrs. Durham cannot speak to and have her evidence considered and weighed and findings of fact made before any other body. And so because that was not afforded to her, because we haven't reached that stage yet, we say that she hasn't been afforded natural justice in terms of the ability to be heard and have her evidence considered and findings of fact.
So how do you say that should be remedied? I don't know if I'm clear on. Mr. Durham, you're muted. Mr. Durham, you're muted. Yes, Mr. Durham, can you hear me?
Yes, my lady.
All right, you were muted for the last 10 or 11 seconds. What my question to you was, what is the remedy that you propose? I don't think I was clear on that from your submission, Ms. Knoll.
The remedy we propose for the curing of what we say was a lack of natural justice, is that what my lady is asking?
What do you want this court to do?
My lady, we want this court to quash the decision, and we want it to be remitted back to the Bar Council for determination, exclusive of the matters we say are not in its remit to consider.
I see. Okay.
Yeah.
Thank you.
And so, my lady, moving on, I'll move to my second point, which is that the existence of the complaints of which the appellant is innocent of until proven guilty have been used to adjudicate her fitness to practice in violation of her right to natural justice. And so again, my lady, it being accepted that natural justice applies to these deliberations, we say that natural justice also encompasses the concept that the appellant is innocent until proven guilty. And this is confirmed in authorities that we have placed before this court, particularly in the case of Fay and Payne v. the Governor of Bermuda Dental Board, which confirmed that Order 6.8 of the Bermuda Constitutional Order encompasses Article 6.1 of the European Convention on Human Rights. Article 6 on a whole provides for the protection of a fair trial. Article 6.2 as an element of a fair trial provides that everyone charged with a criminal offense shall be presumed innocent until presumed guilty, according to law. And then, my lady, we also rely on the case of McCarthy v. Bar Standards, 2017 EWC, wherein the High Court stated at paragraph 64, I have no doubt that this tribunal would have been—
Mr. Durham, I'm trying to follow you. Are you reading from your skeleton submission?
I'm reading from my skeleton, my lady. I'm at paragraph 15 of my skeleton.
15. Okay.
Yes.
Okay, thank you.
Not a problem, my lady.
Yes.
My lady, just as a matter of reference, McCarthy is found at tab I of my bundle.
Mhm. Yes, thank you.
Right. And so carrying on, my lady, what was stated at paragraph 64 of McCarthy was that I have no doubt that this tribunal would have been aware of the elementary principles that the Bar Standard Board bore the burden of proving the appellant's guilt to the high criminal standard, and accordingly, the appellant was innocent until proven guilty. And my lady, it's also to be noted that the Bermuda Bar Act 1974, section 19.5, which is found at tab J of my bundle, provides that the standard of proof required in proceedings before a disciplinary tribunal shall be the same as that required in criminal proceedings. So again, we see here that matters before the Bar Disciplinary Tribunal are determined on the high criminal standard.
Mhm.
And therefore, the appellant would be deemed innocent until proven guilty if her matters proceeded there. I don't think I need to belabor the point in referring to the case of McCalla v. the Disciplinary Committee, which basically confirms the same. And so we say, my lady, following on at paragraph 18 of my skeleton, is that having established that the presumption of innocence applies to persons appearing before the Bermuda Bar Disciplinary Tribunal, as per McCarthy v. Bermuda's Bar Standards Board, and that the presumption of innocence is a necessary element of a fair trial, as per Article 6.2 of the Convention, it would be most unusual if Bar Counsel could lawfully rely on evidence of wrongdoing, of which the appellant was presumed innocent until proven guilty, and which is the subject of an undetermined complaint before the Bar Disciplinary Tribunal. In particular, as Bar Counsel, for the purposes of determining whether a person should be issued a fit and proper certificate, is acting in an adjudicatory function to determine a civil right to practice a profession, no different from the function of the Bar Disciplinary Tribunal. And this was outlined in the case of Youssef v. Solicitors Regulation Authority. And just for your reference, my lady, I believe that's the first case that I refer to, and it is found at tab G of my bundle.
Yes.
And at paragraph 81 of that case, the court stated that the SRA's decision on an application for a certificate that it is satisfied as to the applicant's character and suitability to be a solicitor and for admission to the role is a decision that affects the applicant's freedom to provide legal services and his or her reputation. In that respect, it is no different.
What paragraph were you looking at in Youssef?
Paragraph 81.
Oh, 81, sorry.
Yes, I do apologize. Are you there, my lady?
Nearly. Yes, thank you. It starts the SRA's decision on any application?
Yes.
Mm-hmm.
Again, it says that in that respect, it is no different from decisions that may be taken against solicitors in disciplinary proceedings. Such an applicant is not a person with the mere hope of obtaining a future benefit. The decision is one that affects his rights. As the admission regulations make plain, if the SRA is satisfied as to the applicant's character and suitability to be a solicitor, it is required to issue a certificate of satisfaction, provided that it is also satisfied that he has met the relevant training regulations. And that certificate entitles the applicant to be admitted as a solicitor unless good cause is shown to the contrary. No doubt the SRA must exercise judgment as to whether the objective criteria specified are met in relation to suitability and character, but it has no general, much less an arbitrary discretion to deny a certificate or admission, particularly if its authorization scheme is to comply with the requirements of Part 3 of the Provision of Services Regulations. Such an applicant, therefore, does not merely have a mere hope of obtaining a benefit, as Mr. Dunlop appeared to imply, but even if an applicant merely had such a hope, he would nonetheless be entitled to have his application dealt with fairly. But the point that we want to make, my lady, is that in determining an individual's fit and proper suitability to practice, or as the parallel regulatory regime in the UK requires, character and suitability tests, it's the same effect, and so the same standard ought to be applied. And so we say that if in the bar disciplinary tribunal, one is required to be deemed innocent until proven guilty, and the standard of proof is the same, then it ought not to be a differentiation between what Bar Council can do in determining a fit and proper certificate and what the Bar Disciplinary Tribunal can do in terms of determining whether or not an attorney has conducted himself contrary to the provisions. I hope that's clear, my lady.
Yes, thank you.
And so the next point I wish to raise is that the Bar Disciplinary Tribunals Rule 1997, which is found at tab L of my bundle, requires in section 15, 1, 2, and 3 that subject to the provisions of this rule, where there is evidence before a disciplinary tribunal that a respondent has been the subject of a decision of a court or other tribunal, and it is shown that the decision is relevant to the matters before the tribunal, that decision may be admitted in evidence at the hearing of the charge as prima facie proof that such a decision was made. It requires a decision, not a mere allegation, but a decision. And it continues at section 2, a conviction for a criminal offense may be proved by producing a certified copy of the certificate of conviction relating to the offense, and proof of such a conviction in this manner shall constitute prima facie evidence that the respondent was guilty of such an offense. And then lastly, a finding and sentence of a tribunal exercising a professional disciplinary jurisdiction in Bermuda or overseas may be proved by producing a certified copy of the finding and sentence, and if so proved, shall constitute evidence of such finding or sentence. So it's not merely just allegations that the Bar Disciplinary Tribunal relies on in relation to other tribunal matters that is taken into consideration when determining how to discipline an attorney. It has to be an actual determination. That's not what we have here. We have allegations that have been deemed to amount to prima facie grounds for the hearing of the complaint. But we know from criminal proceedings that, let's say on a no case to answer submission, the court determines that, yes, there's prima facie grounds to continue with the trial, but that is not in itself a determination of innocence or guilt. And so that's what we have here. We have no determination that Mrs. Durham is guilty of any of the charges that the Bar Council relied on. They're merely allegations at this stage.
Okay, thank you.
And my lady, the corollary legislation in the UK, or the corollary regulatory body in the UK, is the Solicitors Regulatory Authority. And our act, the amended section 10E, under which these proceedings fall, appears to be a mirror copy of the 2011 SRA suitability test. But the difference is that they have guidelines in terms of the application of their rules. We seem to have implemented our legislation without any thought to implementation of guidelines that would give us some direction as to how we implicate these procedures. And so we're left in the situation that we are in currently in trying to piece together what criteria we take into consideration and how we go about deliberating these matters, because we simply don't have the guidelines. But the UK legislation provides these guidelines. And so I provided them as a means of giving the court some sort of guidance as to how their application of their rules is carried out. And so I provided the SRA Suitability Test 2011, which is found at tab H of my bundle, my lady.
Yes.
And so if I could draw my lady's attention to the guidance note under section 6.1.
Yes.
Yes. And so you'll see, my lady, that I just want to make sure that I have the right. So you see 6.2, the page starting with "We may refuse your application." My lady,
Yes.
are you there?
Yes, thank you.
Right. And if you go down, you'll see guidance note, and the second one states that you should disclose details of any disciplinary proceedings or investigations you may be facing. We will not determine your application until you can confirm that the matters have either been dropped or the outcome of your case is known. So again, the rationale is clear. We need to know whether or not there's been a determination, a finding of fact in any subsequent or any corollary proceedings before we can legitimately take those into consideration. Because an allegation anyone can make, and it doesn't necessarily prove the matter.
Yes.
And so, my lady, I believe also in my supplemental submissions, I provided the court with the SRA internal policy guidelines, which merely seek to emphasize what I say. My lady,
You made reference to it in your supplemental submissions, you said?
Yes.
Okay. Where, oh, I see it, paragraph 7?
Yes. And the actual document is behind that, my lady.
Yes.
So on the, let's see, 1, 2, 3, 4th page, my lady. You'll see the second last heading, internal SRA decisions.
Yes.
Okay, if I can just take you through that. It states, we rely on criminal convictions in our investigations and when making regulatory and disciplinary decisions, such as the imposition of a Section 43 order or fine and rebuke. In doing so, we will regard a certificate of conviction as conclusive proof that the person in question is guilty of the offense and of the findings of fact upon which it is based. We will take into account material such as sentencing remarks and any other independent information. In exceptional circumstances, we may reconsider the underlying evidence. We also rely on civil court judgments and the decisions of other disciplinary and regulatory authorities in our work. We will generally regard a certified judgment or decision as conclusive proof of the findings reached, including the facts upon which the decision is based. In doing so, we will take into account any relevant evidence, any related evidence, and the surrounding circumstances. We may reconsider the underlying evidence if we consider it appropriate to do so. So again, they rely on a certified judgment. They wait until there's an outcome, and then they can rely on the established facts that have resulted from those proceedings. We're not at that point. The Bar Council were not at that point when they took into consideration the contents of the allegations that were yet to be determined by the Bar Disciplinary Tribunal. And we say, my lady, that has to be unfair. And it has to be in breach of natural justice. And so, my lady, lastly, we refer to what's called the harshness point, that being the third ground of appeal. And we say, and I'm at paragraph 22 of my skeleton argument. Okay. We say, lastly, this ground of appeal is that the Bar Council acted unduly harsh in all circumstances in their determination. It is submitted that the only determination that the Bar Council has actually relied on, other than the other complaints being pending, is the complaint in regard to Myron Bin. So what we say is that is the only.
But we weren't going to name anyone.
I do apologize, Marie. I sort of got caught up. And this resulted in a reprimand. And so we say it's of no sense that a sanction previously resulting in a reprimand in one tribunal can be elevated to a consequence amounting to suspension by another adjudicating body, simply as a result of having taken place within a specified period of time prior to the enactment. It is to be noted that in the case of McCarthy v. Bar Standards Board, which we previously referenced, the court stated at paragraph 68, I accept Mr. Counsel QC's explanation that it was standard practice for the Bar Standards Board to refer the disciplinary tribunal to the sentencing guidelines enforced at the date of the offense, so as not to offend against the general principle codified in Article 7 ECHR, that a court or tribunal ought not to impose a heavier penalty than the one that was applicable at the time the offense was committed. So at the time that Mrs. Durham was reprimanded, the range of applicable sanctions was a reprimand. And having been given a reprimand, she would have considered the matter dealt with, and she would have considered that the tribunal came to a just and proper sentence. Now, because the legislation has been enacted, the means by which Bar Council has applied this legislation has resulted in what was a reprimand now being elevated to something which denies her of a practicing certificate. That just seems irrational. And my lady will be aware, and I make reference in my supplemental submissions to the Bermuda Constitutional Order. Sorry, if I can just take you to the relevant paragraph. Section 6.4 of the Bermuda Constitutional Order provides that no person shall be held to be guilty of a criminal offense on account of any act or omission that did not, at the time it took place, constitute such an offense. And no penalty shall be imposed for any criminal offense that is severer in degree or description than the maximum penalty that might have been imposed for that offense at the time when it was committed. So what we're saying is that has to be contrary to that principle, that you can now look back and say, oh, you were reprimanded 5 years ago. Now, based on this new legislation, that reprimand is now a reason for denying you a practicing certificate. I mean, surely that offends that principle.
Yes.
And so, as I draw to a conclusion, my lady, I do wish to address some of the allegations made in Ms. Christopher's first affidavit.
I do have her second affidavit as well, no.
I'm grateful. But one, my lady, my issue, well, one with the second affidavit is I don't think the court granted leave to file a subsequent application. And certainly at this belated stage, it's not entirely fair to the applicant to not have an opportunity to respond to the same.
Are you asking me to disregard it?
I would, my lady, yes.
Well, not difficult to do if I can't put my hands on it. I know it was brought to me. 1 minute. Oh, okay. I do not disregard it. Do you want to address me on whatever it deals with?
I mean, and I don't think it gets us very much farther, but I can address it in broad terms. Essentially, my lady, if the court is to consider the evidence.
Sorry, just give me a moment to read it, please.
Sure.
It's short. I can read it in just a few minutes.
Yeah. I'm sorry, my lady, have you finished?
No, 1 moment.
Okay, I'm sorry.
Right.
Right. So on a whole, my lady, what Ms. Christopher seems to be attempting to do by way of relitigation, that obviously these additional matters to which she refers, namely the judgment of Earl Matthews, in addition to the, sorry, my wife is off camera, my lady, and she's just reminding me that it was agreed that we refer to initials.
Yes, can you please be more careful, Mr. Durham?
Right.
I mean, much was made about this.
I do appreciate that, my lady. But this is the civil judgment, so it's not the same
I see.
consideration.
Okay.
Yeah. So what we say is that the respondent contends that when Mrs. Durham made her application for fit and proper certificate, she just failed to disclose this finding of fault against her in this case. And under the fit and proper person application prepared by the council, we say that this was not a requirement, or at least it's not a properly understood requirement, because what it asks for is for criminal convictions of fraud or dishonesty, whether a person has been made the subject of a serious disciplinary finding, sanction, or action by any regulatory body, court, or other body hearing appeals in relation to disciplinary or regulatory findings. It's not clear from that that it encompasses a civil judgment. It seems to be emphasizing disciplinary or regulatory findings. And I may be wrong, but the point simply is that it's not readily understood. And so to allege some sort of deliberate non-disclosure by Ms. Durham in relation to this, I think it's unfair. This is the first time that such applications have been required to be made. There's no sort of guidance as to what specific material this encloses, unlike in the SRA regime, where they specifically tell you what it encompasses. That's not the case here.
Yes.
And then, my lady, as to the gravity of it, this was a determination whereby Mrs. Durham was found to be negligent in the exercise of her professional duties because she failed to disclose a conflict of interest. While the judgment date was in 2013, the actual conduct complained of took place in 2009. And my lady, what's relevant is Mrs. Durham was called to the Bermuda bar in 2008. This was just over a year after she had been called to the bar, and acting on her own, not having any supervisory experience counsel, she erred in her professional duty, which the court determined. But the court also went on to say, if I can just find it.
A copy of that judgment?
Yes, the copy of the judgment is found at page 27 of the record of appeal.
Thank you. Yes, thank you.
Yeah, if I'm just putting my hands on it myself. If
It
I
starts
can
with page 7 of the record.
Yeah, correct. If I can refer you to paragraph 66, my lady, it states that I accept that the fifth defendant.
One moment, please, sorry. Yes.
It states that I accept that the fifth defendant started out with the intention of acting in the best interest of all three parties to the conveyance. However, in trying to do that, she ended up breaching our contractual duties to act for Mr. Matthews with reasonable care and skill and with single-minded loyalty. So the judge recognized that she might have started out with good intentions, but possibly due to her inexperience, she fell short of her duty. And this is 10 years prior to this determination by Bar Council. So I don't know whether or not it would have been fair to attach such weight to such a determination so as to deny her a fit and proper certificate, something that happened 10 years ago. And My lady, if I can bring your attention to Ms. Christopher's affidavit, her first one.
Yes.
She states that, if I can put my hands on it myself. I did have it in front of me. I seem to have misplaced it, but in any event, my lady, what she says about the Casaran matter is that Mrs. Durham made, yeah, the initials. What she says about that matter was that she made a partial disclosure. In fact, they were misled by the partial disclosure because they thought it was referring to the MB matter, but in fact, it was referring to the HK matter. And so they were of the understanding that that was the only one that she was referring to. And then they subsequently discovered that there was this HK one. Again, my lady, if that was to be taken into consideration, if that raised concern, it would be our position that Mrs. Durham would have been given the opportunity to come to speak to why she failed to make that disclosure. And the Bar Council would have been in the position of determining whether or not there was any dishonesty. Because if you look at the authorities, my lady, in particular in USEF, what the Bar Council, SRA is concerned with respect to inadequate or incomplete disclosures is whether or not there's an element of dishonesty. And so I don't think that there is any evidence that they can rely on to say that Ms. Durham was dishonest in her partial disclosure. But again, she wasn't given the opportunity to speak to that and to explain why such partial disclosure was made. And of course, the first time that we learned that this was something that they thought would be of relevance is in Ms. Christopher's first affidavit, to which Ms. Durham did not have leave to respond to. And so, my lady, I think that in conclusion, on this point, we say that it was unduly harsh for the Bar Council to make the determination that it did, in light of the only relevant considerations, which would have been in our submissions, the 2 reprimands. And we say that because previously these could have only amounted to decisions that may have resulted in a fine. But now, due to the passage of time and the change in legislation, they've been elevated to matters that can now be used to deny a practice certificate, which just appears to be patently unfair, my lady. So, my lady, I will rest my submissions there unless I could be of any further assistance.
No, that was very clear and helpful. Thank you, Mr. Durham.
Thank you.
Yes, my lady. If I may start with the respondent's position on this. Firstly, I can submit that the respondents do not take this position with the position they find themselves in with any degree of levity. There is no joy that comes from the regulatory function of having to now grapple with the change in the legislation. It is submitted, however, that the change in the legislation, although, as my learned friend puts it, is patently unfair.
Can you take me through these changes? Can I see some sort of a comparative demonstration of the changes that you're referring to?
My lady, I can take you to the Bermuda Bar Act.
Or you can even just explain them to me?
Yes, I can explain them to you, but it may be easier if I can. 1 minute.
I just would like to see what the before and after positions are.
Right. The before and after positions of the 2019 January amendments are that it gave the Bermuda Bar Council the ability to
19th of January, what, this year?
19th of January 2019.
2019, thank you.
The amendments came into force, and the amendments were the induction of Section 10E of the Act, which are headed fit and proper persons.
Yep.
Within that scope, it gives the Bar Council to look at every barrister and registered associate and every shareholder, controller, and director, and senior executive who exercises control of a professional company, and it states that they must be fit and proper.
What was it before?
It was not in existence prior to January
So
2009.
10E is a completely new section.
It's a completely new section.
So how was the exercise performed in the issuance of practicing certificates?
Prior to that, the application for a practicing certificate was put forward to the Bermuda. The application was put forward to the Bermuda Bar Council. It required the disclosure of criminal convictions, but it did not require
Pursuant to a provision under the Bermuda Bar Act?
yes, pursuant to a provision under the Bermuda Bar Act.
Do you know what that provision? I'd like to take a look at that provision if I might.
Yes, 1 minute. I'm just taking up the section 10. My lady, if I can just go to the practicing certificate section 10 of the Bermuda Bar Act. It states that the council, on application in writing by a barrister in the month of November in any year, in such form as the council may determine, and on payment of such fee as may be prescribed by rules, and upon being satisfied that the person to whom the application relates is qualified to practice as a barrister, shall, in accordance with this part, issue to the applicant a practicing certificate as a barrister for the period of 1 calendar year from the 1st of January next. A barrister shall be entitled to a practicing certificate if he is admitted in accordance with Section 51 of the Supreme Court and has not been removed or struck off the roll. He possesses a Bermudian status within the meaning of Bermuda Immigration and Protection Act. He possesses a permit, valid permit, not applicable in this case.
Sorry, I just feel like you skipped off, and just for the record, it said, and has not been suspended under Section 57 or removed or struck off the roll. Just for the sake of completion under subsection A.
Yes, that's a complete reading of that paragraph. C, that he is not in default in the payment of fees prescribed by the Bermuda Bar Association. D, he or his firm of barristers or a professional company of which he is a member or an employee. E, repealed. F, he has within the prescribed 12 months immediately preceding the date on which he has applied for a practicing certificate, complied with the applicable CLE, continuing learning education program requirements. The council has issued him with a fit and proper person certificate. Now, this is a consequence of the amendment that was made in 2019, the inclusion of the fit and proper person certificate, which became a prerequisite before the issuing of a practicing certificate or reviewing the application for a practicing certificate. And G, so I'll just read that. The council has issued to him a fit and proper person certificate within the period of 90 days immediately preceding the date on which he applies for a practicing certificate. G, this is with respect to the holding of insurance.
Insurance, right.
Yeah.
And then the H is evidence in relation to AML and ATF.
Yes. Yes.
Issues.
So
Okay. So that's essentially that was a standalone provision
That was a standalone provision
against which, I see.
prior to the enactment of the amendment.
Okay. So we're really just concerned with a new section 10E.
Yes, that's what we are concerned.
Thank you.
And the novelty of this section is what brings us before these courts at this time, as the enactment meant that as of January 2019, the Bar Council was seized of having to first, and before going through the applications for practicing certificates, had to issue the members of the fraternity with an application for a fit and proper certificate. If I could, my lady, take you to the record of appeal. An example of the fit and proper is actually there at page 1, which is the application of Ms. Keiva Durham, the appellant in these proceedings.
Yes.
And this section, this application form sets out the section that is reflected in the act, and it requests that the applicant fill in or answer certain questions with respect to their standing and whether or not, and in order to provide the council with the ability to assess whether that person is fit and proper. So if we can just go to the Bermuda, form that's before my lady, hopefully. We have section 10E lifted completely straight from the act. I think it is an important feature of this to go through this section. It is not long, but it is of utmost importance considering the gravity of it entails for the members of the Bermuda Bar, but also Ms. Durham specifically in light of these proceedings. Section 10E1 states—
Sorry, before you go on, Ms. Tucker, tell me something. Was section 10E specifically designed to cure any defect that might have existed in the previous practice, or was it aimed at ensuring, I don't know, some considerations that were not previously available?
In short answer to that, my lady, I can say that what I know is that the fit and proper person certificate, the fit and proper person provision was enacted because of a growing number of allegations, both in the private sector and in the public sector, in terms of criminal allegations that were being levied against members of the Bermuda Bar Association. It was meant, I believe, it was in my view, to address the concerns of the public and to better ensure a public protection in the council's ability to assess the standings of persons that are representatives of the Bermuda Bar and are providing services to members of the public. Protecting the public from harm, I believe, was something missing from the original application process for a practicing certificate. And this was enacted to cure or give some degree of confidence to the members of the public as a matter of public policy that attorneys that have the privilege of being considered as practicing members of the Bermuda Bar do have a degree of good standing and can essentially be trusted with matters of importance with respect to clients that come through the doors.
Thank you.
Now, if I can go to 10E1, every barrister, it states that every barrister and registered associate and every shareholder, controller, director, and senior executive who exercises control of a professional company must be a fit and proper person to engage in the practice of law. 2, on an application to the council for a fit and proper person certificate by a person who wishes to engage in the practice of law, the council shall determine whether that person is a fit and proper person. And in making that determination, the council shall act fairly and in good faith in respect of each person. In determining whether a person is a fit and proper person, the council shall, with a view to protecting the interests of clients, potential clients, and the public, and in the interest of protecting the integrity of the profession as a whole, shall have regard to the matter set out at sections 4, 5, and 6. We move on to section 4. And my lady, as we go,
Subsection 4.
yes, as we go through these sections,
Mhm.
I would like to make certain submissions that arise during the course of the sections as we meet them with respect to this appellant. So section 4, the council shall consider the previous conduct and activities in business or financial matters of the person and shall have regard in particular to A, evidence that the person has been convicted by a court of a criminal offense. 2, involving dishonest fraud, perjury, or bribery. 3, associated with obstructing the course of justice. And 4, associated with money laundering or terrorism. This is the applicant's application, she has commented not applicable there. And any other applicant who was a member of the bar making this application would have to fill out specifically whether or not there is any evidence of them being convicted by a court of a criminal offense. B, evidence that the person has been convicted by a court of more than one criminal offense. Again, the appellant has put NA, and any other member of the bar would have had to complete if they've had more than one criminal offense. And that would have been something that the council would rightfully take into consideration.
Sorry, let me make sure I didn't miss the last, your voice dropped in the last sentence.
I'm
Did you make some sort of complaint about her answer, her last answer, her not applicable answer?
No, I don't make a complaint about her last answer, my lady. What
Okay.
I'm merely stating is that any other applicant would have had to fill out that same section, and then that section would have been audited by the council themselves.
Okay.
C, material evidence that the person has been responsible for behavior which is dishonest or violent,
Mhm.
involves a misuse of any position to obtain a pecuniary advantage, involves a misuse of any position of trust, demonstrates that the person cannot be relied upon to discharge his financial duties as a barrister. Now, as you would have seen from the, 1 minute, my lady. The letter with respect to the denial of the appellant's application for her certificate of the council at page 98 of
Yes.
the record state, we have considered the severity of all the relevant circumstances. However, in reviewing your previous conduct and activities in business and or financial matters, bar counsel must deny your application for a fit and proper certificate, and therefore will decline to issue you with a practicing certificate. And if you go to the next page, page 97, my lady, it is put that under fit and proper person's determination, in making its determination, bar counsel considered your previous conduct and activities, my apologies, and that, in particular, the bar counsel have regard to the following: 10E4C4, which is what we read out, that you have demonstrated that you cannot be relied upon to discharge your financial duties as a barrister, as you have 3 pending PCC tribunal matters that are all in relation to financial complaints. And then at that time, we had 1 admonishment with respect to financial matters.
So why don't we just cut to your bottom line position so that I can follow you closely as you go through it.
Okay. Yeah, bottom line position.
What do you say to Mr. Durham's overriding point that these are complaints? These are not adjudicated matters. These are allegations that have yet to be determined.
Yes.
On their merits.
What is being submitted with respect to that is that in its remit as the council has the ability to take all matters into account with respect to the appellant when she makes her application to be given her fit and proper person certificate.
And it has to do so reasonably.
It has to do so reasonably, but in doing so,
and fairly.
We are to look at, my lady, the material evidence that we have at our disposal. Material evidence, we state, is the not only the findings against the complainant, but the regulatory history of the complainant. I mean, of the appellant. The regulatory.
Before you get into the history for a moment, I just want to be clear on what your response is to the unadjudicated claims.
The response to the unadjudicated claims is that the complaints themselves reflected evidence which the council considered material to whether or not the appellant would be considered fit and proper.
So they themselves determine the merits of that, notwithstanding that there's a process by which those kinds of complaints are determined.
The council hasn't determined the merits of the complaints. We've looked at the complaints in what they have disclosed regarding financial matters. It's not just the complaint itself, it's the circumstances of the complaint and also the numbers of the complaints that the Bar Council has looked at. The Bar Council, the purpose of this act is to protect the public. And the Bar Council's onus is to ensure that we are doing so on the basis that in good faith and fairness, we're looking at the complaints that are being put forward. We are assessing them and what they are disclosing. And then we are looking at the picture as a whole with respect to that particular applicant. The reason why there is, first of all, it's at the discretion of the Bar Council to what material it considers as a whole. But secondly, the application process is open every year so that if matters change and there may be findings or the process is complete, the appellant can then make an application, disclose the outcomes or findings or withdrawals, and can potentially be issued a certificate within the next run or calendar year or whenever matters are disposed of. The reality is that this is a reaction. This legislation is a reaction to what is complained of as financial untoward activity of members of the fraternity. So when we have evidence of complaints that are before us, we have the ability to assess them. Now, where the Bar Council in its supplemental submission have accepted is that the appellant quite possibly should have been given notice of what we were planning on doing and why she should be considered as having exceptional circumstances under Section 6 of that TAN-E. Why she should be considered as having exceptional circumstances before the council actually does make its decision and either allow or deny her. And in doing so, we failed in writing to her. The council failed in writing to her, and the position is that is. If we were going to consider all the factors and put it to her, then yes, we have failed. But we are looking to the responses that she has provided in her affidavit evidence with respect to the material. And as the second affidavit of the president has pointed out, the council would have likely still been in the same position as taking the decision to deny Ms. Keiva Durham her fit and proper person for the year of 2019-2020.
So how do you propose that I dispose of this appeal? What's your position?
Well, first of all, we're barring the three outstanding matters that had not been completed. There are also three matters that the court can properly consider at this stage with respect to fitness and propriety of the appellant. Those matters have yielded findings of courts, of tribunals, and of the PCC. It is the submission that one is enough for the Bar Council to consider that a person is not fit and proper. With respect to this particular appellant, we have 3 different courts that have found financial impropriety with respect to the activities of the appellant during the course of her provision of legal services. We have now, and we've provided the court with the update of PCC matters. There are 5 active matters that actively engage the financial, or they actively put forward allegations of financial impropriety on the part of the appellant. And we will be asking that this court dispose of this matter by way of dismissing this appeal. The reality is that the appellant has the ability to continue to make application year in and year out as the position changes. She can supply any reasons or any further developmental programs, business courses, accounting outsourcing. She can provide a level of changes that would fundamentally, I would say, impact upon the decision of the respondent when it exercises its discretion under this new act. The appellant, we do agree with the appellant that there are no guidelines with respect to what is to be submitted at the time of the application and what is to be considered in terms of you must hit X, you must have X, Y, and Z cases in terms of or no cases against you. We just don't have a threshold with respect to what can be considered a fit and proper person within this jurisdiction. We have, however, 3 significant findings, and we have we have matters in lieu. And this is something that the Bar Council must take account of when it comes to consider the fit and proper standing of its members. And that is the response to how we will propose that you do dispose of this appeal with respect to dismissing it, and basically asserting that the Bar Council does have the discretion, and it is within the remit of the Bar Council to look at all the material that it has available to it, and most of which was not disclosed by the appellant. The appellant is relying on mistakes and errors on her part, but the point and her obligation is to put forward the chairman's report with respect to her admonishment and fine. It's to alert us to court findings that specifically spoke to her practice and significant amounts of monies that had to be returned to clients as a result of votes. It's to address names and particulars with respect to what's required. We have the appellant, which is why the council states partial disclosure, because not only do we have no date of the finding, the specific date, we have no name of the one disclosed finding against her. The Bar Council had to dig after once we had this appeal, which is what became, which brought to light the other 2 matters that the appellant was involved with, in addition to the MB matter, which is cited on the Bar Council's letter, which we believe was the only matter due to the very slight disclosure, being that what she states is I was fined, and in 2016, I was fined by the Bar Council for the failure to pay stamp duty on a conveyance. That's with very little particularity, and it definitely and most certainly doesn't disclose the whole picture in terms of the appellant's regulatory history with the Bermuda bar. And she is required to do so within the last 5 years. I understand my learned friend, Mr. Durham, to be asserting or submitting that these matters, that the actual acts complained of, the acts happened prior to the 5 years, but the findings occurred within the last 5 years from 2019. That would have meant that she had to disclose matters since 2014 and findings against
What
her.
is it that she should have disclosed that she did not?
We say that she did not disclose. If I can take you to the, if I can take you to the record of appeal, we have the chairman's report at page 3. Now, if you can see, the chairman's report is one that was as a result of an appeal from the Bar Disciplinary Tribunal. And the findings are such that it was found at paragraph 2 that she did breach the code in that she engaged in conduct which might otherwise bring the profession into disrepute. She breached the code in that she had failed to be competent, diligent, and efficient in her professional activities. And she had breached the code with respect to barristers' accounts and records, in that she improperly paid money out of a trust. It goes into the underlying factual circumstances, but at the end, Ms. Durham was found to be reprimanded. She was also found to pay costs, and she was also fined.
No, but what were the guilty acts that she was found to have committed or breached?
So if we go to paragraph 3, which is at page 4, it stated that she completed the transaction before she received all purchase monies from her client.
Sorry, you said paragraph 4?
Paragraph 3.
3, the underlying allegations.
Yes.
These all, this is a list of the allegations against her, yes?
Yes.
But what were the findings?
Oh, yes, my apologies. The findings were at paragraph 8, specifically paragraph 8.4, that Mrs. Durham had let the vendors down. She had exposed them to the risk of criminal penalty for late payment of stamp duty. The vendors had suffered the considerable embarrassment and inconvenience of being chased for some months by the tax commissioner for stamp duty post-completion.
Okay, well, she disclosed the matters related to stamp duty. So what is it that she did not disclose that she was found to have been guilty of?
This was the issue. I bring it to the court's attention because this was not the matter that touched MB. When we looked in our records with respect to MB was in 2016, and it was an admonishment as a result of some anomalies with respect to financials.
Okay, so 1 minute. There's no complaint that she had not properly disclosed everything in relation to the HK.
There's no complaint to that. No.
Okay.
It's just we're not aware of it we're not aware that it pertained to HK at the time.
Right. Now take me to MB.
MB.
There were findings made by the court in respect of MB?
No, we do not have findings from the court with respect to MB. There is findings from the PCC with respect to MB.
Findings from?
It's from 2016. I'm just having a look at the record. One minute, my lady. My lady, I can't seem to put my hand on the MB finding.
I mean, in the context of my question, which is your submission is that she was guilty of non-disclosure or partial non-disclosure. And you made complaint about her response where she only talked about her failure to make good stamp duty.
Right.
So my question to you, which followed, was, well, what should she have disclosed? And
Well,
so you're now taking me to these various complaints.
Yeah.
But my answer, my question is unanswered all the same. You can even tell me, but what is it that she was supposed to have disclosed that she did not? That was an actual finding against her.
She did not disclose the reprimand with respect to the MB account situation, and she did not disclose the civil court action with respect to her professional duties and responsibilities, the discharge of those.
Okay, one moment.
I'm sorry, ma'am, my lady, if I can assist, the MB letter is found at page 99 of the record of appeal, where it sets out what the circumstances were. Yes.
All right, thank you.
Thank you, Mr. Dahl.
No problem.
So this was treated informally.
Yes, my lady.
You're saying that she should have disclosed this. Is it fair to characterize this letter as an informal warning?
It's fair to characterize this letter as an informal warning. However, it is part of the regulatory history of the appellant with the Bar Council, and unfortunately, we did not connect the KM matter to the MB matter, so the KM matter wasn't really properly considered at the time in terms of the gravity that.
Yes, but sorry, I just wanted to stick to one point at a time. This is, we're still on the issue of non-disclosure.
Yes.
The non-disclosure aspects of her application form.
Yes.
And you say that she should have disclosed this informal letter as part of her regulatory or disciplinary history?
Yes.
And that's what you make complaint of in turn when you say that she has been guilty of non-disclosure?
Yes.
Okay, I'll just make a note, 1 minute. Is there any other acts of non-disclosure that your client relies on?
We do rely on the civil court judgment against
Yes.
the appellant. That's at page 7. Now,
So that's the 10th of April 2015 judgment.
yes, and that would have
Justice Hellman. Okay.
yes, that would have fallen within the remit of the 5 years, specifically with respect to the findings of the former Honorable Justice Hellman. The findings of, or the summary of the findings are paragraph 66. in that he accepted that the fifth defendant, who was the appellant, started out with the intention of acting in the best interest of all three parties to the conveyance. However, in trying to do that, she ended up breaching her contractual duties to act for Mr. Matthews with reasonable care and skill and with single-minded loyalty. I am satisfied that her breach of those duties caused him loss. The amount of loss was the value of his interest in the property as at the date of the conveyance, namely $225,000. I order that the fifth defendant pay damages to the plaintiff in that sum. Now, we say that this is disclosable, one, because of the finding of a court, which touches her profession, and her service provisions to her clients and how she goes about that. But it also carried with it a hefty penalty. And as a member of the association, for the appellant to submit that, because this is a court judgment and not an appeal finding, we think takes us nowhere. The fact is that it's a finding of the court with respect to the professional services that were rendered by Ms. Durham to her clients, one of which resulted in a hefty pecuniary loss to that client, which she was found to be negligent and had to repay. Mm-hmm. And in failing to disclose a finding of the court with respect to her professional obligations, we say is also a material non-disclosure that's relevant to the fit and proper person certificate and what it's meant to encompass. And although it wasn't before us at the time that we were deliberating, or that the council were deliberating the applicant's application, it is now before this court. And that would make it 3 findings, although one may be of less concern to this court. One we would submit is more than enough, and one that would give the council pause, or would have given the council pause, and given it the power and ability to exercise its discretion to not provide the appellant with a fit and proper person certificate at that time.
So, Ms. Tucker, let me ask you this. You accept that these are discretionary considerations on the part of the Bar Council?
Yes.
It's a discretionary exercise altogether, in fact.
Yes.
Yes. Is it suggested in taking into consideration these non-disclosures that there was some underlying dishonest intent?
It is not suggested that there's any dishonest intent. However, my learned friend stated that she wasn't granted leave to produce a further affidavit with respect to addressing that. My learned friend certainly has had this information for at least.
No, I'm talking about from the perspective of the Bar Council. Let's put aside for a moment any positive answer that Ms. Durham might make to the suggestion of dishonesty. Mm-hmm. Is it that the Bar Council, in taking these non-disclosures into consideration, considered these to be of a dishonest nature, or did it accept that these may have just been inadvertent errors made on the part of Ms. Durham?
At this stage, my lady, we can't say that it was dishonesty. We don't want to purport dishonesty, and we don't find that it was dishonest. We can accept and appreciate what my learned friend has submitted in terms of the newness for everyone with respect to the application, what's required, what's not required. We can definitely appreciate that that confusion, if you want to call it that, on the part of the appellant. And we, as in the Bar Council, continue to refine the process as it goes on. However, we would still submit on behalf of the council that these are findings that it could properly consider now, and could have then if it had it at the time.
So, for example, if there were evidence before me on which I found it irresistible to conclude that these were oversights, would it have been harsh on the part of the Bar Council to take into consideration non-disclosures of this nature?
Would it have been harsh on the council to take into its consideration non-disclosures?
Of a character, you know, of a nature where it suggested that it was just a mere oversight.
It would definitely move the non-disclosure completely off the spectrum of things to consider. We would not consider the non-disclosure in terms of one additional mar against the appellant, if that's what the court is asking. The non-disclosure would have happened, and it would have been considered to be an innocent disclosure, and it wouldn't have given a black axe over the appellant's application as a whole.
And I'm sorry, just remind me, is that one of the cited reasons in the 9th of December 2019 letter?
It's not one of the cited reasons, my lady, as I submitted earlier. Once this appeal came about and we had to then prepare, that's when it was discovered that there was the chairman's report with respect to the KM, sorry, I think it's the KM, and this judgment. So it was not in our consideration. But as this court is hearing this matter somewhat afresh, if the court in this instance does find that it was an innocent disclosure, then we would accept and appreciate that position.
I see. Yes.
Yes. Now, if I can just take this court to the 1 minute. I would like to take the court at this moment to the matters that were not adjudicated, but were also considered, which are the 3 matters that are listed in this rejection letter. And if I can do so by taking this court to the affidavit of Miss Elizabeth Christopher.
Let me just pause you for a moment, because while I have to say I have the stamina to continue, I'm just looking at the hour. It's now 10 to 1. How much longer do you propose to be? And
I would myself
that we just continue through the lunch hour. What's the proposal?
If the court is able and willing to take an hour's break, perhaps, and we just reconvene at 2, I do need a comfort break in any event.
Does it have to be as long as an hour?
It does not have to be. I'm happy to take half an hour, 45 minutes.
Let me see what Mr. Durham.
I'm fine with any length of time the court wants to adjourn it for.
Well, how about this? We can do something in between. Why don't we come back at 1:30? I will ask the court administrator to just leave the court smart running if necessary, and just put your cameras on mute and take off the video, and then we can just come back at 1:30.
Okay.
I'm grateful.
Is this a convenient point for you to stop, Miss?
It is a convenient point.
Okay, okay, good. All right. Thank you. So we'll come back at 1:30.
Thank you.
All right. Yes, thank you. Good afternoon to you both. I hope you both feel refreshed. It's a short break, but at least we can finish up this afternoon without too much delay, I hope.
Yes.
I'm great.
My lady, I can just indicate where I am with my submission.
Yes.
I am just going to deal with the 3 matters that are listed as the matters that are pending before the PCC. And I am just going to deal with 2 points that the respondent raises on the cases he relied on.
Okay.
So firstly, with respect to the 3 pending complaints, I would like to first turn to the page 30 of the record of appeal.
Mhm.
This is the JB complaint. And if you go to the following page, the complaints are as follows. Or I should say the complaints that the Bar Council are concerned about are as follows. One, amicus law.
Sorry, can I just understand the context of what this document is? This is a letter from the,
This is a letter from the complainant JB.
yes, to the Bar Council effectively.
Yes,
Okay.
this is a complaint.
And is this the initial complaint or is this just,
This is the initial complaint.
okay, thank you.
And it's undated. I can't help with when this was received.
Is there any dispute as to what roughly when this was made?
No, my lady.
When, so what's the time frame?
I'm thinking 2018 because amicus provided a response in 2018.
Okay, so 2018, maybe initial. All right, yes.
Okay, so one, amicus law firm took the car money. They sold the car from my brother and Mr. White and held it for a year. Two, amicus law firm submitted bills to social insurance that had already been paid in order for funds to be released.
Mhm.
We are not concerned with the third complaint.
Okay,
Four, when my mom had to go away for treatment, she put my granny and others on bank accounts, she as in Miss Durham,
mhm.
so that they could pay her bills while she was away for likely periods. I guess lengthy periods, that should be.
Okay.
My mom's grandchildren only received half of what was in my mom's accounts because amicus law firm gave the other half to the other account holder.
Mhm.
Five, when amicus law firm finally confirmed they had sent the money for my children at the end of October, they advised that they made an error in a wire transfer and sent it in BDA dollars, and it was rejected, and they will send again that day. I tried for weeks to follow up. I had threatened amicus law firm with my lawyer to visit them for them to deposit the money in December. As of 31st of December 2017, the money to my granny and aunt still has not been paid to them. Now, amicus provide a response. Mr. Durham could perhaps deal with that in his reply, but what we were concerned with is the response to the amicus law response.
Okay,
And
that's on the very next page.
yes, page 34.
Yep.
I'm going to take you to portions of this document, and it may be just easier to have a highlight to hand. So first, point one. My belief that my children and my brother's children were entitled to my mother's pension came from Ms. Durham herself. At the reading of the will,
I don't see where you're reading from. You said the first page.
I'm sorry, the first point on page 34.
Oh, 34.
Yeah, I'm not going to be addressing the amicus response. Mr. Durham can do that in reply if he so wishes.
Ah, okay. So let's see. Sorry, give me 1 minute. Okay, 34.1, Miss So-and-so's complaints.
Yes.
Yep.
So this is the response to the reply from amicus.
Mm-hmm.
My belief that my children and my brother's children were entitled to my mother's pension came from Miss Durham herself. At the reading of the will, I took minutes, and she advised that my mom left her money to her grandchildren. I asked the question if that meant all her money, pension and insurance, and Miss Durham said yes, but the insurance was left to my brother and I go down now to the bottom of that page, about 5 lines up where you see the number 1.
Yes.
1. There was something not quite right about the request from amicus law firm regarding the pension. According to social insurance, Ms. Durham initially asked for the pension to be given to her firm based on what they were, based on they were the executor and social insurance, was reluctant and asked to see my mom's will and only would give the firm the money if they gave it to my aunt or granny. Social insurance claimed that Ms. Durham submitted bills that needed to be paid in order to receive the pension funds. Or I or my brother could have gone directly to them and submitted forms to advise that we felt we were entitled, as they questioned why the law firm had asked my brother and I to sign forms. 5, they were reluctant to give amicus the pension because the money would have gone to them as they were listed as the executors of the estate. 6, although my brother and I are over the age 18, the statute does not specify what would happen in a situation where the children are older than 18, and also does not specify that it could go to the residuary.
Ms. Tucker, let me just pause you there for a moment. I was curious where you were going to go with this, only because I anticipated maybe that you were going to point to some response from amicus that accepted the allegations against them or something of the like.
Right.
But what you've shown me so far, is it not fair to just describe this as particulars of the allegations against Ms. Durham?
Yes, particulars of the allegations, yes. But I'm not solely relying on that. I wanted to point to what my intention here is to show where there is somewhat of a level of concrete evidence in terms of paperwork and in terms of documents that have been seized by the clients themselves that show and have been given to the bar counsel that showed that there may have been some impropriety in terms of how transactions emerged or could have emerged. So our remit was not to get into the merits, as so to speak, as who's guilty and who's innocent, because as my learned friend Mr. Dorn rightfully points out, that's for the PCC, and that is their role in this.
What's the status of this complaint?
This complaint, the status.
I'm looking at the back of the second affidavit from Ms. Elizabeth Christopher, and I don't see anything that makes me think it's related to this matter on the chart.
Let me see. If you're looking at the chart, it's actually under JM. I believe it was maybe someone got married or something happened, but it's JM initially.
But they're different first names.
A second. No, if you go to page 38,
38?
Yes.
Of the record, right?
Yes.
Okay.
The complainant's name is there, J. At the
Oh,
bottom.
I see. Oh, I see. Okay. So it does refer to this. All right. And there's a pending tribunal action?
Yes, a pending tribunal action on this. So the concerns were with respect to a pension fund that belonged to the deceased at the time.
But what weight do you want me to attach to the allegations when there's a pending tribunal action? I mean, can I properly, or could the bar counsel have properly stepped in to make any findings on a matter that has not been?
We couldn't have stepped in to make any findings, but you know what? I may just I wanted to kind of bring this to a crescendo, but I think I'm going to go to my last point on this matter, which is actually in the respondents, bundle.
Okay.
And I'm looking at.
You say the respondent, you mean the appellant?
The appellant, my apologies.
Okay.
I'm oftentimes the appellant. If we can go to the guidelines, the solicitor's regulatory guidelines provided at tab G.
Yes.
Sorry, not tab G.
Tab H.
Yeah. If we go to section 6.1,
Right.
and then we go over to section 6.2,
Mm-hmm.
we go down to the guidance note, which my friend pointed out
Read to
earlier,
me, yes.
and we go to 6.2.2, the
Mhm.
second part of that guidance note. It reads, you should disclose details of any and all disciplinary proceedings or investigations you may be facing. We will not determine your application until you can confirm that the matter has either been dropped or the outcome of your case is known.
But that's to do with disclosure.
It's
Your
to do with,
complaint is not about the non-disclosure of this. Your complaint, as I understand it, you can correct me if I'm wrong, but your complaint is about the truth of the allegations.
yes, my lady, it is about disclosure. I can most certainly say that. But the second part is that the application for this person's fit and proper in the same context is not going to be heard or determined until the matters that are facing the tribunals have been heard. So what I'm relying on here is that not only have you a situation where you have pending matters which have not been disclosed.
Oh, I see. You rely on this to say that the practice is when you have pending applications against you, those applications have to be disposed of before the tribunal, sorry, not the tribunal, but the bar council will consider your application.
That is exactly what we're
see.
In addition to that, my lady,
is that fair?
I believe that most certainly is fair because we have an overriding objective in protecting the public.
Mm-hmm.
We have situations where there is a growing number of complaints. There are two in addition to the updated chart that you received with respect to Ms. Christopher's second affidavit. You will see the last two are actually new matters. And as we deliberate and consider fit and proper statuses, there is no privilege in having the ability to continue practicing and potentially further causing damage to the public because the matter hasn't been heard yet.
But do I not have to balance that against the fact that this is a complaint that was made in 2018? We're now in 2021. And I have not heard you make reference to any sort of tribunal date hearing, but my guess is that has a hearing date been set?
I have not heard of a hearing date being set as of yet. And I do note what my lady is saying with respect to the balance on the expediency of the system. Now, putting that in context, we also have to mirror that with the amendment to the legislation, which came about in 2009, and the plethora of unfortunate 2019. Mm-hmm. Yes, mm-hmm. We have an unfortunate situation in having almost, I don't want to say molasses-like, a molasses-like PCC in the past that may not have expedited things as quickly as needed to happen. And one of those reasons could have potentially been because there were no real ramifications to that or a detriment to that counsel in practicing with the time passing.
Well, how is anything different? If this came into, if Section 10E came into effect in January 2019, we're now in June 2021. And right. A complaint that was made in somewhere in 2018 has not yet been finally adjudicated. What's improved?
The only position that I could take with respect to that is that yes, firstly, we have to acknowledge that we have a system that is on the mend in terms of how complaints are being dealt with the PCC. However, we also have a situation where we have an unfortunately high volume of complaints that have to be dealt with the PCC. And although we have a delay in the findings, the reasons why we say that we consider everything in terms of of the complaints, and then in terms of what we see within the complaints. We are looking at not just the volume, but what they contain, what the history is in terms of the number of allegations with respect to this complainant. And that's why the council chose to act in the way that it did at the material time. I can't answer the question on the delay in terms of how the function of the PCC operates, but based on the updates, the matters are continuing to move and be heard. Now, if the court, or move to be heard, if the court is of the view or takes a position that the appellant should not be unduly penalized because of a delayed system, the position would then be that the fit and proper didn't come in into 2019. So the delay at that stage would have been from 2019 up until the application, when the application process first started, which is the 2019 year. So we had a year essentially to try to expedite this matter in terms of before the PCC, these matters before the PCC, but that did not occur. So we've looked at the evidence, we've looked at what we find evidence which is somewhat concrete in terms of material evidence, which we are entitled to take into account and form a view as to whether or not we are going to, the council is going to deny a certificate. So when I go to the cases that are pending, the ones that we had at the time, not the new ones, we're looking at just evidence that was before the council at the time, which was material evidence that pointed to improper conduct as a firm in relation to financial matters. And I'm not looking at serious allegations. We're looking at where the complainants have actually attached evidence or documents from departments that they've contacted and things of that sort to reach conclusions. So, or draw an inference with respect to what we consider to be activity that is fit and proper. So if I look at, say for instance, the complaint from LW, we have a situation of a second complaint that's pending, and
where's LW? Where am I looking?
LW is at page 39 of the record.
39 of the record, okay.
So if that page is pulled up, my lady, you have a situation here where you have a complainant who in 2010 executed a conveyance and had delivered to the appellant a conveyance and requested that the returned document, which was the conveyance, be dated and stamped. And as of 2017, when this complaint was received, that dated and stamped conveyance had not been, that date stamped conveyance had not been returned. What that pointed out was that there could be potential malfeasance with respect to the payment of stamp duty and stamp fees, which was estimated to be around $35,000. Despite what my learned friend and the appellant has placed in her affidavit, there is a delay here of 7 years with respect to delivery of a date stamped conveyance. And as you can see from the at least the matter involving.
Was this the subject of the admonishment?
No, this is pending.
This is also pending. Okay, thank you.
That's what I was going to point to, because the admonishment does also touch the similar circumstances in terms of fact and how the appellant executes her affairs regarding conveyances. That is a matter that is, I think it's been charged approved before the PCC.
Right.
1 minute. I'll then move on to then the last pending complaint that was considered, which is at page 51
51.
of the record. And you will see here what I'm just going to be pointing to are the allegations with respect to finances that were of concern and piggybacked on the other financial improprieties that were being alleged and the findings that were made out before the tribunal courts or appeals court. So if I can just take my lady to the subheading improper communication, but onto the second page, page 52.
Yes.
At just after the end of the first sentence, Mrs. Durham had the Amicus Accounts Department send me bills in reference to doing things on my behalf for my mother's estate, when I've had to make mention of numerous times, even in meetings, as stated above, to leave it alone. Mrs. Durham has had the Amicus Accounts Department mail me bills stating that she had drafted letters on my behalf, which I had no knowledge of, attending meetings in the courts and meetings with me, which is false, specifically concerning the matters of my mother's estate. Every meeting I've had with Mrs. Durham, she would insist in mentioning my mother's case, and I'd have to interrupt to direct to another case that she's mentioning. So this was with respect to billings. And on the next page, or billings for work that hadn't been requested. And then on the next page, at paragraph 1 on that page, under failures in doing and completing agreed task, 1, in the year of 2009, I was told by a U.S. immigration officer at the airport that I was put on the stop list for overextending my stay by 2 weeks past the 6 months allowance time due to the fact that my mother was residing at this particular hospital. Mrs. Durham agreed to help me apply to retain my visa back. I was told it would cost $200 to apply online first for a waiver first and $500 for Mrs. Durham's services. I specifically asked for the specific help with retaining my original visa, not a waiver, for I have no illegal convictions, just overstayed for medical reasons concerning my mother, as I was a trustee of my mother's care. So far, they had me fill out pages that printed from the U.S. immigration website that I could have done myself. They got the police record, and that's it. I paid over $600 so far for this and have yet to see exactly what I hired Mrs. Durham to do in the matter. I'm still awaiting to hear sorry, I went on, but that was just another situation that this complainant had with respect to what work's being done and what, like, the monies that are being paid over and received. So we looked at the context of the 3 pending matters, and we put them in the light of the matter that we had an admonishment and fine, which she had accepted existed. We later found that we had 2 additional matters that were left off on the disclosure side, and all of these matters, inclusive of the new matters, which we are not addressing in the context of this case, but we draw the court's attention to, all revolve around financial impropriety. And the consequence and harm, even though minimum, when you look at $600 here or billing for work here that never was done or may not have ever been done. In the grand scheme of things and in the scope of what's happening, you're looking at a situation where this is going all the way to the consulates in terms of complaints. Nothing has been done to remedy and address the situation in terms of from the appellant herself with her clients. We're now seized of all of this evidence, and we, in our discretion, must consider all the regulatory history and what's before us when we come to reach a decision with respect to the fit and proper. And it would be my further submission that in allowing the appellant to benefit from practice, when there are not only the similar allegations, but also several numbers of them from a host of individuals that are not interrelated brings an alarm to the court, to the counsel's attention. And that alarm is meant to be cured by the discretion that the counsel has, but for exceptional circumstances. Now, the exceptional circumstances, it is accepted that we didn't have them at the time, but I can state that we've been through the affidavit of my friend, the appellant, and as Miss Christopher rightly points out, or does point out in her second affidavit, that the counsel still would have been minded to remove or not approve the certificate of the appellant. And I would just like, in conclusion, to bring the last case that my learned friend relied on, the Youssef case, to the fore, because I think it's one important thing in particular that I want to take from this case. And that's with respect to the context of this case. And if I can take the court to that judgment, which is at
I have Yusuf in front of me.
okay. If I can take that court to paragraph 3. 3? Yes, under the introduction.
Yep.
It states on April 29, 2014, she submitted her first application to the SRA for admission as a solicitor and for a practicing certificate. In her application form, in response to the question whether she had a county court judgment issued against her, Ms. Youssef's answer was no. In fact, as she then knew, she had such a judgment issued against her by the Woolwich County Court in the sum of £4,891 on October 30th, 2009. In the event, Ms. Youssef ultimately withdrew her application on the 12th of 2015. I go to the next paragraph. Ms. Youssef submitted a separate application for admission as a solicitor and for practicing and a practicing certificate on 8th of March 2016. That application was dismissed by the adjudicator for failure to disclose, and she acted with dishonesty. With respect to paragraph 5, I just want to point out that she appealed against
Miss Tucker, when you read these extracts, so would you read them fully, because you may miss material portions. He found she acted dishonestly when making her first application by failing to disclose the 2009 judgment. I think that's not a part to skip over.
Yes, my apologies.
Mm-hmm.
And also that during the consideration of that application, she had provided misleading information to the SRA in relation to its existence and to her knowledge of it. The adjudicator based his decision on the documents he had without affording Ms. Youssef an oral hearing. I bring that to the fore because I think it touches directly on the disclosure point, but putting that to one side, this was a situation where there was only one judgment against this person that ended up causing her to be denied her practicing certificate. So when we're talking about at least having just one and being unduly harsh, I think we have to weigh it in context of.
Yeah, but there was a finding of dishonesty. It's not a count. It's not a competition on the numbers. It's really a question of what findings have been made.
My lady, yes, I mean, the reality is that I don't, the outcome of this matter actually is one which the appeal was allowed because of an oral, it was found that she had not been able to have an oral hearing. And I would say that we don't know what the ultimate outcome of her actual, of the actual decision was with respect to her certificate. But the oral hearing problem is being cured with respect to Ms. Durham's situation with these arguments that are being presented to the court today. So the Youssef case is one that may not necessarily be as quintessential as it's made out.
Let me ask you, Ms. Tucker, are you able to point me to any authority where a professional regulatory body has withheld any sort of practice and certificate based on unadjudicated claims?
I am not able to point you to the authority. I think the issue.
I think what you showed me was in terms of what's in 6.1 or 2, I think it was, of the SRA guidelines was very helpful. But is there any sort of authority which endorses that practice?
I cannot say that I have been able to access an authority because as you can see from the SRA guidelines, the SRA wouldn't entertain the application.
Yes, but that might have been challenged or anything. I mean, I'm asking whether or not there's any case that might have come up on judicial review, any sort of appeal.
I must say that the SRA or the Solicitors Regulatory Authority in the UK are the only persons that I found to be of a similar legislative framework, and I was unable to find any case that would have I guess encompassed the same elements as the case that's currently before the court. I'm not certain as to what occurred prior to the 2011.
But even outside of the legal profession, for example, the medical profession or any other professional body where there has been the withdrawal or the withholding of a practice and certificate on the basis of pending allegations.
My lady, I can certainly say that if they do exist somewhere in one of the Commonwealth jurisdictions, I have myself not located an authority that assists with our ability to argue this case in terms of the pending actions and taking them into consideration. What we relied on at the time and what the council relied on, I must say, is just the provision which states all material which may indicate, and we used all material to reflect all evidence and all matters at our disposal, which included the new complaints.
Thank you.
So with that being said, and then bringing it to conclusion, I would like to reiterate the fact that despite the failure to provide notice to the appellant and with respect to our decision, had we provided her with that notice, the appellant would have likely very much so been in the same position that she was in with respect to her approval, or sorry, the lack of approval for her fit and proper certificate for the 2019-2020 year. That is as a result of the, at the time, the one actual finding, which now is apparent is 3 within the time frame. And in light of the 3 pending matters, which were of similar ilk regarding finances and conveyancing inappropriate conduct regarding those things. We are now in a situation where barristers and attorneys have to take account of the overriding objective and their obligations and duties to their clients and to themselves. And the Bar Council, under the new legislation, acted in the discretion that it felt that it had at the time, and did so in good faith with respect to the appellant, and did so with the heavy understanding that the financial misgivings of members of the Bermuda bar profession are constantly highlighted and bringing the profession into disrepute. And members of the public have to be protected to a certain degree with respect to the regulatory authority and our remit to not grant fit and proper person certificates in light of everything and all the material that it has before it regarding any applicant.
Right.
And that's the end of my submission. Thank you.
Ms. Tucker, thank you for your submissions. Mr. Durham, do you want to reply on points of law?
A couple points, my lady. My learned friend referred to section 6.2 of the SRA suitability test, which we provided in our bundle.
Yes.
I think what's important is to understand how that regime applies. And you'll note from the first page, under the preamble, you'll see a heading applicability. And it applies to students and trainee solicitors under the SRA training regulations, qualified lawyers under the qualified lawyer transfer scheme regulations. So that's lawyers from other jurisdictions, it's my understanding. Those seeking admission as solicitors under the admissions regulations, fulfilling the duties under the Section 3 of the Solicitors Act 1974. My lady, it's my understanding that that is when you're firstly seeking to be admitted to the role as a solicitor.
All right.
And lastly is those seeking to become authorized role holders in accordance with rules 8.5 and 8.6 of the SRA authorization rules. So my point is that it's my understanding, and I may be wrong, but I don't think that this test applies in the same manner as we seek to apply our test, i.e. every year to a solicitor who has already been granted admission to practice as a solicitor. It's for persons seeking to enter into the practice of a solicitor. And so in that context, 6.2 kind of takes on a different color, because what it's saying is you're applying to be entered into the profession, but we need to see any pre-existing tribunal matters before we make that determination. So it's a difference between removal of a right to practice and granting a right to practice. Here, in relation to the SRA guidelines, they're dealing with the granting of a civil right to practice, whereas here we're dealing with the removal of a right. So my point is that it's somewhat unfair to take into consideration pending matters in relation to removal of the right to practice.
So, I mean, this is in your bundle. You relied on it.
Yes.
As some sort of a guideline for
Yes.
this court.
Mm-hmm.
Do you come away from that?
No, I just say it applies differently. It's the same principle of fairness. We need a determination, but it's a determination before we can grant you the right to practice, not a determination that we'll rely on to remove you from practicing.
So what is the what is the, I mean, is that something that you can file for me, perhaps following this hearing, what the actual renewal?
Sorry, what the actual?
What the actual renewal
procedure is?
Procedure is?
I can certainly undertake to, my lady, and if I'm unable to, I'll notify you.
Okay.
And so lastly, my lady,
Just sorry, before you go on from that, is there an inference that I should draw from the absence of any document like this for the renewal? Can I not infer from that that there is no robust regime to examine practicing solicitors, if you will, once you have gotten through the initial suitability test?
I
Do you understand my question, or should I, it was a bit convoluted?
Yeah, I think so, my lady, but I don't want to presume, so I'd be grateful if you could further clarify.
All right. I understand from you that this suitability test is the initial phase of they're for new practitioners.
Mm-hmm.
And whether they be new because they've just qualified or new because they've just transferred to the jurisdiction or whatever the case may be, but
Yes, that's my understanding.
Newly admitted members who
Yes.
practicing bar.
Yes.
And it would then follow that the suitability test would be more stringent in that initial phase than it would be for someone who is simply going for a renewal of their application.
Quite possibly.
That's what I understand. I think that I'm restating your submission. I just want to make sure I understand you correctly.
I think that's fair, my lady. And I think how it would be dealt with subsequent to someone being applied to the role would be that if there was such a complaint, the SRA would investigate the complaint, and then they would make a determination to transfer the matter to the solicitor's disciplinary tribunal. And then the tribunal would be seized of dealing with any infractions of the rules. So they would not, the SRA at that point would not determine character and suitability. They would simply determine whether or not the matter needs to proceed to the SDT. At least that's my understanding. If I'm incorrect about it, then I do apologize.
Well, I mean, just on that point, I think it would be fair for me to allow you maybe a 7-day period to file any document that might apply, whether they be guidelines or another suitability test or anything of the like that would apply to a renewal application.
Sure.
I can tell you just while I'm on that point of a 7-day period within which to file that, I would also be minded to grant both of you the opportunity to file any authority where there is any judicial approval of the withholding of a practicing certificate from any profession, any professional regulatory body, based on allegations or complaints which have yet to be finally determined.
I'm grateful, my lady. I think I share in Ms. Tucker's challenges to find such authority up to this point. It obviously various jurisdictions have their different regimes, but I haven't as yet come across an authority that points to the powers being that broad, despite my multitude of efforts.
I mean, but doesn't that avail you to the baseline submission that you make, that it's not done? I mean, does that not lend to your case that if there is no authority by which one can say that the courts have placed any sort of value on an allegation which has not been determined as a basis for withholding a practicing certificate, then that would be wrong in principle to do?
I agree, my lady. And broadly, that sort of submission would fall under the common law principles of natural justice. And my lady, one more thing. My learned friend characterized the MB matter as relating to financial matters. My lady, I think that may be a generous assessment. It related to the return of a file and the delay in doing so.
Mm-hmm.
And then, as I conclude, my lady, The problem.
That was the informal warning letter?
Yes,
Yeah.
yes. And so, my lady, just to crystallize the point, if it is always the case that a pending matter can be used as evidence to deny a practicing certificate, then all that's necessary to deny someone a practicing certificate is not a tribunal decision, but it's never having a tribunal decision. The question is, what happens to Mrs. Durham if these matters are never brought before the tribunal? Whenever she applies, it'll be the case that, hey, there's a pending tribunal matter. And they can simply never determine that matter and always rely on that. It just seems irrational. And that's my closing point, my lady.
Okay, thank you. I'm going to maintain that you have a 7-day period to file anything of the description that I've given, but there's no pressure on you to do so.
I'm grateful.
I'm just pretty confident that I will not give you a written ruling within the next 7 days. And so there's no harm by giving you that opportunity. Please do not misconstrue that as an opportunity for further submissions or written submissions or affidavit evidence or anything of the like.
I'm grateful.
I've heard your various arguments. You don't need to contextualize any case that you give me beyond what you deem to be necessary, beyond what you would do if you were in front of me now. So it may be about whatever the case is, but please don't fall prey to any temptation to just re-argue the case in a written submission. That will not be necessary. I think both of you have been crystal clear in your opposing positions.
I'm grateful.
So that being said, I will reserve judgment and provide in draft a written decision that you can give some editorial input and see what, if any, further applications may arise from that.
I'm grateful, my lady.
Okay. All right.
Thank you.
Thank you.
Thank you.